From the Library of Congress in Washington, D.C.
Good afternoon, everyone. Thank you for joining us. Welcome to the Library of Congress. My name is David Mount. I'm the Deputy Librarian of Congress. We are here to celebrate Constitution Day. It's a federal observance that is officially titled Constitution Day and Citizenship Day, because it not only commemorates the signing of the Constitution, but also recognizes all of those folks who either by coming of age or by naturalization have become citizens of our great country. And I know all of you are thinking right now, you remember back from history class or your social studies class, well, the Constitution was actually signed on September 17th. And in fact, one of our speakers right before this asked, well, isn't tomorrow Constitution Day? And absolutely right. But here at the Library of Congress, we're just so excited. We love the Constitution so much, we just wanted to get a jump start on the 228th celebration of the Constitution. So thank you again for being here. Today, we're going to offer the program Religious Freedom and the American Constitution, and we're really, really delighted to have two great speakers with us today. We have Princeton University Professor of Jurisprudence, Robert P. George, and Wall Street Journal Supreme Court Correspondent Jess Bravin. They will be discussing the First Amendment to the Constitution, which, as most of us know, forbids Congress from both promoting one religion over another and also restricting an individual's religious practices. Just to give you a quick summary, Professor George is the McCormick Professor of Jurisprudence at Princeton and the founder and director of the James Madison Program in American Ideals and Institutions. He's also a visiting professor at Harvard Law School and chairman of the U.S. Commission on International Religious Freedom. Jess Bravin has covered the Supreme Court for the Wall Street Journal since 2005. Prior to that, he had been posted at the Papers United Nations correspondent and also editor of the Wall Street Journal California Weekly. Jess has written for other papers, including the Chicago Tribune, the Los Angeles Times, the Philadelphia Inquirer, the Washington Post, among others. So with that quick introduction, I want you to join me in welcoming both Professor George and Jess Bravin to the stage today. Thank you very much.
Okay, well, let me begin here. Well, thanks for taking time out from your Constitution Day shopping and Constitution Day meal and the Constitution Day tree to come and think about the real meaning of Constitution Day, which, of course, involves the great fundamental freedoms of our country. And it's a great occasion. And also the Law Library is a great institution, not only for me when I've occasionally done research there, but also really for students and citizens around the country online. There's tremendous resources available, and there's a phone number to call to get help with research projects. So I just want to put in that plug to overburden the Law Library's resources a little bit. It really is a great institution, even though they've gotten us here today. So anyway, so let me just, what we're going to do is we're going to have a conversation. We have a few questions that we'll bandy about. Professor George has a lot to say about these things, and towards the end we'll take some of your questions to cover the things we've missed. But let me start. Professor George is a great public intellectual. I'm just a newspaper reporter seeking clicks. So let me say, I will just put these words out there now. Kim Davis will talk about her and her religious freedom claim at the end, so you'll have to stay for the entire presentation. But to tease it out a little bit more, I will say this. Professor George may or may not know this, but the presidential candidates have been queried about their favorite books and movies and songs and so forth. And Governor Mike Huckabee indicated that his favorite philosopher and intellectual was Professor George. So as a bit of background to build some suspense when we get around to the Kim Davis question. But now it's time for broccoli. One thing we want to do is sort of trace the origin and development of jurisprudence around the religion clause or clauses, depending how you view them in the First Amendment, and then the related oath clause in the Constitution. And as we look back to the founding documents of our country, the Mayflower Compact, the original things we saw in the 17th century were quite religious in nature. That was the reason that many of the colonists came over to the Americas to leave the European sort of semi-theocratic states and so forth. The Declaration of Independence in 1776 invokes God several times, the creator, the judge of the world, and so on, doubtless for sincere religious reasons. Also, perhaps, if you need an authority to justify your treachery towards your king, there's only one person or entity above that, and so if you want to find who outranks the king, perhaps God would be someone you'd want to invoke, as well as other principles that come up in the Declaration of Independence. Once we come to the Constitution of the United States, however, apart from the clauses regarding religious rights or protecting imposition of religious belief in the Oath Clause, there's no God. It's a godless document. And we then, of course, after 1789, the Constitution is ratified. Then we have the First Amendment and the Establishment and free exercise provisions. What does that tell us about the nature of our country and the relationship its founding documents have with religion and religious exercise?
Well, thank you, Jess, and I'll say a word directly in response to that question. But first, I wanted to thank you for being my interlocutor today, and thank David and the great staff here at the Library of Congress for inviting the two of us to talk with you about the Constitution and really to celebrate the Constitution, as we should every year at about this time.
On or about.
I want to say a special word of thanks to Leah Caravallo, who was really instrumental in putting this together, and I'm so grateful. Also grateful for your hospitality and welcoming my parents who came along from West Virginia, and I want to thank my cousin John and my cousin Teresa for driving my folks over. And then I look out in the audience and I see so many friends. Boy, I feel at home. So many of you have come, some from long distances up in Pennsylvania, Pastor Ricky Phillips and Alf Sewers. And I see Saba is here, Yuval Levin, so many of my dear friends. Thanks for coming out. Jess has asked a very important question. God seems to be everywhere in our Declaration of Independence, right at the heart of the thing. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. And really, that's just the beginning, as Jess has pointed out. And yet, when we get to the Constitution itself, we don't see references to the Creator. And so that's led some people to ask the question, does the Constitution, especially in its Establishment Clause, which was added with the other provisions of the Bill of Rights quite shortly after ratification of the original Constitution, does the Constitution deliberately leave God out of the picture? And more importantly, does it establish the kind of strong, dogmatic separation of church and state that one finds, for example, in the French laïcité system? I think the answer to that, if we look at the historical record, is pretty clear. The Constitution is not designed to establish anything like French laïcité. It is certainly not designed to establish secularism as the established religion or quasi-religion of the United States, or to place secularism in the role that religion would play in a theocratic or quasi-theocratic regime. The Constitution, remember, had a very particular purpose. It was a charter of government, and it was meant to establish and empower and yet limit the power of a set of institutions at the central level, a central government that would be strong enough to be able to give the country the kind of governmental support that you need to be a country, unite the separate former colonies that were now states as a country, regulate commerce among the states, without which regulation you're in constant danger of the country simply falling apart, and enable the United States to take its place among the nations of the world as a great nation in the family of nations. That was the point. The Constitution left everything else to the states and to the people respectively. And that included an awful lot of what we can speak of using the old common law language as public health, safety, and morals, and a concern for the common good. So when we hear Washington speaking, of course, in his farewell address, well after we have our Constitution in place and our Bill of Rights in place, when we hear Washington saying that religion and morality are the fundamental supports on which the system rests, or when we hear Adams say, our Constitution is made for a religious and moral people and will not suffice for any other kind of people, we can make sense of that. We're not left scratching our heads wondering, well, didn't Adams, didn't Washington get the message that we have a godless Constitution that establishes something like secularism as the official public philosophy of the United States? We have to remember that the Constitution had a particular objective, and there were particular limits on what the federal government was empowered to do. Everything else was really left to the states. Now, one of the things that the federal government was not empowered to do was to set up an established church. Even before we got our so-called Establishment Clause or Establishment provision of the First Amendment, Congress shall make no law respecting an establishment of religion, even before that was in place, Congress could not establish a national church for the simple reason that the Constitution had conferred no power, had delegated no power to the national government to establish the church. Nor did Congress have the power to interfere with religious freedom or the freedom of speech or the press or the right of the people to assemble. And we could go on through the Bill of Rights. And yet, although that helps us to explain why the Constitution, as originally framed and ratified, did not have a Bill of Rights, and it helps us to understand why a founder as great as Hamilton, great defender of the Constitution, actively opposed adding a Bill of Rights. Still, some people, important people, people with influence, argued that we needed a Bill of Rights in order to reinforce these provisions that would prevent Congress from doing things we think Congress ought not to be doing, ought not to be done at the federal level, including establishing a religion. Now, did this mean, the next question would be, does this mean that the framers and ratifiers of the Constitution and the American people at the time were against having state religions wholesale? Now, that's an interesting question. The answer is some were and some weren't. And as a matter of fact, what is often forgotten in debates about the Establishment Clause, even over there in the Marble Temple sometimes with justices writing opinions in Establishment Clause cases, what's so often forgotten is that several of our states had established churches. Those churches were not disestablished by the Constitution. They were not disestablished by the First Amendment, by its Establishment Clause. Some carried on even as late into the 1830s. As a matter of fact, those state establishments were protected by the Establishment Clause. The clause, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, very neatly and concisely forbids Congress from setting up a national church akin to the Anglican Church in Britain, and stops the Congress from interfering with the state churches, with the established churches in the state. So Congress can't disestablish them by statute. Congress can't interfere with their activities. Congress can't tax the state churches. Do a little thought experiment. Imagine yourself as Solicitor General for a state that's got an established church in, say, I don't know, 1817 or 1821. Imagine it's Connecticut, and imagine it's the Congregational Church that's the established church. Now, by 1817 or 1821, we've got our Constitution, we have our Bill of Rights, we have our First Amendment, we have our Establishment Clause. Let's now say Congress enacted a bill disestablishing the Congregational Church in Connecticut because the majority in Congress didn't like the idea of state establishments. You're the Solicitor General, and it's your job to defend your state's right to have an established church. It's your job to defend the state establishment. What would you say in defending your state's position? You'd say two things. The first thing you would say is, Your Honors, Congress has been given no power to act against the state establishments. Congress lacks any delegated power to interfere with Connecticut's decision to establish the Congregational Church. But you wouldn't be left simply with the absence of a delegated power. In virtue of the existence of the Establishment Clause, you would now be in a position to say, and by the way, I've got some text. That text is the First Amendment to the Constitution in its very first words. Congress shall make no law respecting an establishment of religion. A law purporting to disestablish the Church of Connecticut, the Congregational Church of Connecticut, is a textbook case. It's dead on a case of a law respecting an establishment of religion. And of course, you would have won the case. Now, does that mean that even today, a state could establish a religion? Well, the argument there...
Well, we have, we have at least one member of the Supreme Court who's quite open to that argument, if he hasn't gone all the way. Justice Thomas has mentioned that and has suggested that that this original understanding, in his view, indicates that much of the subsequent jurisprudence around the Establishment Clause may not be accurate in his position.
So then the question would be, does the Equal Protection Clause of the 14th Amendment forbid the reestablishment of the Congregational Church of Connecticut, for example? Now, the argument there would be, it would appeal to what in law school Jess and I learned to call the incorporation doctrine, the idea that the 14th Amendment incorporates and applies against the states the provisions of the Bill of Rights that run against the Congress. Now, there's a hot debate. There's long been a debate over the validity of the incorporation doctrine, although it's pretty well established, I think, at this point. Again, Justice Thomas calls it into question, but most of the other justices leave it in place. And there's certainly no technical or logical problem with incorporating and applying against the states an actual rights claim, like the right to free exercise of religion, or the right to freedom of speech, or the right to freedom of the press, or the right of the people to assemble and petition the government for redress of grievances. There's no logical problem with incorporating and applying against the states the very prohibitions the Constitution places against the federal government. But there is a problem with the Establishment Clause. Because how do you incorporate, logically, how do you incorporate and apply against the state a provision that, at least in significant part, is meant to protect a state prerogative? To see the problem, just imagine another thought experiment. Imagine someone proposing that we incorporate the 10th Amendment and apply it against the states. Now, the 10th Amendment simply reminds everyone that powers not delegated by the Constitution to the national government are reserved to the states, respectively, or to the people, or into the people. Now, given that what's being protected there are state prerogatives, you can't really logically incorporate it and apply it against the states. So even the 14th Amendment, if we're serious about the original understanding of the Establishment Clause, even on the 14th Amendment theory, on the equal protection theory, it's hard to find a credible case for interpreting the Establishment Clause the way it has been interpreted to forbid state establishments of religion.
And yet the Supreme Court has managed to do that, and it might be, well, Justice Thomas has again suggested very much at this point that there are structural arguments that suggest even if you buy incorporation for the other provisions of the Bill of Rights, that for the Establishment Clause, the argument is weaker, he has said. On the other hand, you could also look at the premise of the 14th Amendment and other amendments subsequent, which is that when the Bill of Rights was adopted, when the initial Constitution was adopted, the framers had in mind, they were concerned about the new federal government tyrannically oppressing individuals and so forth. As history turned out, the federal government was relatively impotent, and it was the states that got ahead of the game of oppressing individuals through slavery and various other measures that led to this post-Civil War shift towards the federal government. And since the point of the 14th Amendment was to restrain states, was to stop them from interfering with individual rights, if the idea that being taxed to support an establishment of religion is a violation of individual rights, why is it so hard to imagine that the same restriction that was seen as impermissible for the federal government, the nation looking back as in 1868, decades after every state on its own accord had gotten out of the religion business, why is it so hard to imagine that this is simply supposed to kind of set that in stone?
Well, you need an anchor for where the right is. The 14th Amendment, of course, itself does not supply that. What the 14th Amendment says in its pertinent parts, after the first sentence establishing the citizenship of people who are born and naturalized in the United States, ensuring that they're citizens not only of the United States but of the state in which they reside. And the obvious intent of that is to make sure that the southern states that are now back in, fully back in the Union, cannot deny citizenship to their black citizens. The next part of the first section of the amendment gives us the three great provisions, that the privileges and immunities of citizens of the United States cannot be denied by the state. So if you've got a privilege or immunity that you have in virtue of your national citizenship, the state can't take it away. It's not the state's to take away. And then you have the provision of the 14th Amendment that says that no state shall deny any person of life, liberty, or property without due process of law. The concern there, obviously, is that the judges, and particularly the judges in the southern states, would not afford the same due process protections to black citizens as to white citizens. And alas, despite the existence of the clause there, that happened for more than 100 years. And then the Equal Protection Clause, the clause that says, nor shall any state deny any person the equal protection of the laws. I think the way to proceed in the kind of argument you have in mind, Jess, would be to reframe the argument against taxation to support somebody else's church as a free exercise argument, and then make the incorporation claim based not on the Establishment Clause, but on the Free Exercise Clause. And at a minimum, if that were regarded as successful, at a minimum, it would mean that you could not be compelled against your conscience to contribute money to support a church that you didn't belong to. Now, that would, of course, raise all sorts of interesting questions about how far that extends. Does that mean that that states can't supply aid on an impartial, non-sectarian basis to religious and other private schools? What would it mean for something like vouchers, the constitutionality of which the Supreme Court has now upheld, but by a narrow 5-4 majority? But I do think that the way to respect the integrity of the Constitution and to avoid just making the Constitution an invitation to whoever's got the power of interpretation to read whatever rights they want to into the Constitution, I think the way to handle that is to think about something like taxation to support a church as a religious freedom claim rather than as a non-establishment claim.
Can I ask just a brief historical digression? Why, as you say, about half the states had some form of either established church or taxation to support churches or religious institutions at the time of the Constitution. Why did they all get out of that business by the 1830s?
I think probably the reality of pluralism, that as people traveled more and more between states, states were no longer associated with one overwhelmingly with one religious denomination. Maryland, of course, was the Catholic state. It very soon after that became an anti-Catholic state, but it was originally the Catholic state. Of course, the Quakers were very strong in Pennsylvania, the Congregationalists up in New England, the Anglicans in places like South Carolina. And I think what happened is the religious diversity naturally caused people to think, well, look, it just doesn't work to have a single state established religion. Now, what did not happen, we see this, for example, from Tocqueville's writings, what we did not get is a conception of separation of church and state that pushed religion out of public life. Tocqueville, in his great work, Democracy in America, notices, as a Frenchman, a post-revolutionary Frenchman would, the vibrancy of religion in the United States and its effect on public life, on public affairs. People make religious arguments in the public square. People appeal to religious principles. And of course, that became a very strong part of our tradition going all the way up into the civil rights movement. So someone like Martin Luther King is obviously bringing his religiously inspired moral convictions about justice and the common good into his arguments in public life against the evils of racial injustice. So this is another respect in which our doctrine of religious freedom and even of state-church separation differs significantly from European doctrines, and especially the French Revolutionary idea, the laïcité idea that separates not only church from state, the institutions of the church from the institutions of the state, but separates or attempts to separate religion from public life and push religion into the purely private sphere. I think this explains, for example, why we Americans are made very uneasy, and I think we should be, my own personal normative view is we should be made very uneasy, by efforts in France and Belgium, for example, to forbid Muslim girls from wearing the hijab, the headscarf, in public schools. Or Jewish girls from wearing a little Star of David, or Christian girls from wearing a cross. We in the United States, I think because of our traditions and our understanding of separation of church and state, one that does not relegate religion to the private sphere, we think it's perfectly natural and good and an aspect of religious freedom for people to be able to express themselves religiously, even in public places, even in public institutions, even in public schools. Well, this is very different from the attitude in a nation or nations that are shaped by the French Revolution, not the American Revolution, that are shaped by the doctrine of laïcité. I think what's critical for us, and I think we're right about this, I would defend the American position very strongly. We think no one should hold political office in virtue of a religious appointment, an ecclesiastical appointment. And no one should hold ecclesiastical office in virtue of a political appointment. So even in a country that's very much like ours and whose system we very much respect, great ally, England, Britain, when we see bishops being appointed effectively by the Prime Minister, when we saw the Methodist Margaret Thatcher appointing Anglican bishops, we scratch our heads and say, well, wait a minute. That's not good. You know, maybe they like that over here, but we wouldn't want that. They like it over there, but we wouldn't want that over here. We don't want George W. Bush or Barack Obama appointing bishops or preachers or anything like that. And we also don't want things to work the other way either, where a religious leader appoints, in virtue of that religious leader's ecclesiastical authority, people to political offices.
Well, they have that there too, right? The bishops are in the House of Lords. They have their
exactly right.
So,
that is exactly right. The bishops are really part of the political system over there. But notice that at our best, we don't go to the opposite extreme of saying to our bishops or to our imams or our rabbis or religious leaders, you guys stick to the temple, stick to the synagogue, stick to the church, and don't have, stay out of public life. We think that it was great that a Baptist preacher preaching from his Baptist heart in religious terms, Martin Luther King would come out and say the things that he said in defense of racial justice and people's rights. And it's the same. I mean, the Catholic bishops, the Jewish community, the people of, including religious leaders of all faiths, feel free to weigh in. Sometimes they make submissions to Congress, even appear and testify before the Congress. We don't try to push them into the closet. We don't try to push them into the private sphere. At least we shouldn't. We're at our best, I think, when we don't. We have a view of the public square, and I think it's shaped by our Constitution, really, a view of the public square that is neither the naked public square of French laïcité, don't wear your hijab in public, don't wear your Star of David, don't wear your cross. It's not the naked public square, but it's also not the sacred public square where the ecclesiastical majority controls the public square. The late great public intellectual Richard John Newhouse described our situation as the civil public square, the public square in which people of all faiths and people of no faith can come into the public square, make their arguments in the terms that they are comfortable with, in the terms that are meaningful to them, and vie for the allegiance of their fellow citizens.
But doesn't that cause us to have a perpetual mess? Because finding the distinction, I mean, at least you can say if you have a purely secular system, you know where the line is. In England, which of course, like France, in our country is a democracy, yet their head of state is also the head of the church. So formally, she's the defender of the faith, and so on. So we know that there's not going to be an issue regarding religious presence in the public sphere, even if pragmatically there's not a huge difference in policy or whatnot. But here in this country, it seems like we're always struggling to find the line. And I wanted to ask you about a case that the Supreme Court had about 10 years ago involving two displays of the Ten Commandments in public spaces. One was on the grounds of the state capitol in Texas, and one was in a courthouse in Kentucky. And yet the Supreme Court found that one display of the Ten Commandments was constitutional and the other was not. And I believe the commandments were the same in both
Yes, that's
both states. So what does that tell us about what the Establishment Clause is, or is understood at least by our judiciary?
Yeah. Well, one thing I would urge is that we just acknowledge that we have to live with the fact that there are going to be blurry lines. There will be gray areas. And that doesn't count against the American constitutional system. It works. And it has worked, and it has worked well. Think of how religiously diverse our country is. It began as a religiously diverse country, all the different Protestant sects and a few Catholics and a very small Jewish community. And it's gotten even more diverse. And guess what? We don't go around killing each other. I mentioned some of my on the basis of religion. I mentioned some of my friends who are here today. As it happens, I'm a Catholic. My friend Ricky is a Lutheran pastor. I mentioned Saba is Muslim. I mentioned Yuval is Jewish. Here in America, we have a set of shared values, and those shared values enable us to unite despite our theological differences, the historical, traditional, religious differences. Now, those shared values, I think it's important to note, are not independent of these religious traditions. It's just that we all affirm, if that's Judy Giuliani, tell her I'll call her back. If you have to be old enough to remember that joke. Rather, we affirm those values from the perspective of our different faiths. And when we do that, we notice that there is really a tremendous amount of overlap. The best example of this, obviously, is the Golden Rule. For those of us from the Christian tradition will recognize the rule is do unto others as you would have them do unto you. It's associated, of course, with Jesus' teaching. But if we look at the Muslim faith, if we look at the Jewish faith, if we look at the Eastern faiths, the Hindu and Buddhist traditions, we find something very much like the Golden Rule in these traditions. And that's just one example of that common ground. So we have a system that we all, I think, should affirm and support and protect, even though there are going to be hard cases and blurry lines and gray areas and areas in which reasonable people of goodwill disagree. And in those cases, they're going to go up to the Supreme Court or they're going to go over to Congress. And sometimes my side's going to win and sometimes the other guy's side is going to win. And we shouldn't be too upset about all that. It's better to have the system we have that has done so well. And again, even Tocqueville notices how in America, this great diversity of sects, and yet the public square flourishes. And the same is true in 2015. So I think we should support the system. Now, as for particular cases, I've got a particular point of view. There are three possibilities here on something like the Ten Commandments case. One possibility is to say, Ten Commandments, they come from the Bible. The Bible is a Jewish document, that at least that part of the Bible is a Jewish document that the Christians have also affirmed. The Ten Commandments are a religious teaching. We cannot have the state, the government, endorse a religious teaching. Therefore, the Ten Commandments ought not to be displayed. That's possibility one. Possibility two is to say the Ten Commandments are ethical teachings. They are the teachings of ethical monotheism, what sociologists call ethical monotheism. This is the tradition of the Christians, it's the tradition of the Jews, it's the traditions of the Muslims. The idea is that there is a God, that he has created human beings, that he loves human beings, he wills the good for human beings, that he wills that human beings be good and that they be good to each other. Ethical monotheism. Because the Ten Commandments are not the expression of a particular theological doctrine like Jesus is the second person of the Blessed Trinity, born of the Virgin Mary, but rather an ethical teaching, which is exactly the ethical teaching that we find in our political and constitutional traditions. It's ethical monotheism that we find in that sentence I quoted earlier from the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights. Because the teachings of the Ten Commandments have that status, they can legitimately constitutionally be displayed, and in fact, they should be displayed. We should remind ourselves that it's this tradition of ethical monotheism that is at the very foundation of our constitutional and political legal system. Right there in the heart of the Declaration of Independence. Now, as it happens, that's my view. Okay? Now, the third possibility. This is Justice Stevens' view. Well, the Ten Commandments are of historical significance. And so they have a legitimate place in being displayed. It's legitimate to display them for historical reasons. It is not legitimate to display them for religious reasons. So do we display them or do we not display them? Here's how Justice Breyer resolves that. He says, it depends on the context of the display. If the Ten Commandments are part of a larger display of historical documents or historical monuments that might refer to the Code of Hammurabi, the Magna Carta, the Constitution itself, then fine, it's constitutional to have the Ten Commandments as part. But if the Ten Commandments are just up there on their own, without other historical documents or monuments being there, then they must be playing a purely religious or theological role, and so it's unconstitutional to display them in that context. That caused Jess, I've remembered something Jess said. Jess and I had a phone call, get acquainted a few days ago. Jess had a line, I'm going to steal your line, Jess, because it was so good, where he said, this is a bit of a caricature, of course, but it makes a point, that you can display the Ten Commandments when they're meaningless, but you can't display them when they have any actual religious meaning. Now, it's a pretty telling point, actually, against Justice Breyer's position. I think he would see it differently and try to mount a defense against that. But you can see what it's after. My problem with that, and the reason I favor that second position, is that I do not think you can detach the historical from the religious significance of something like the Ten Commandments. We are not a technically religious nation. We are not a constitutionally Christian nation, the way England is officially a Christian nation. But we are, it's just unavoidable. I mean, we are what Justice William O. Douglas, one of the most liberal justices ever to sit on the court, what Justice William O. Douglas said we were in 1953 when he said that this is a religious people, that the American Constitution is founded on a kind of religious, it's a non-sectarian religious teaching, it's ethical monotheism. I'm trying to remember the exact quotation from Zorak against Clausen, 1953. If somebody can,
Someone wants to care to Google that for us?
Right, you can get it. But what he was pointing to, I think, is absolutely right. Now Douglas sort of went off in a very different direction in his own constitutional jurisprudence from where he began in Zorak, or where he was in Zorak against Clausen. But I think what he said there is right. When we affirm the teaching of the Declaration of Independence, that we really do hold these truths to be self-evident, that all men really are created equal, that they really are endowed by their Creator with certain unalienable rights, we're not just making an historical statement there. We're making a very important American political statement. We're saying this: the most fundamental rights human beings have, the rights to life, liberty, and the pursuit of happiness, or life, the most basic aspects of our human reality that are being protected by our constitutional law. These are not the gift of a king or a Congress, a president, or even a Supreme Court. They're not the gift of any human power. They were given by a power far above any human power. And because they're not the gift of a government, no government can legitimately take them away. Rather, it is the obligation of government to, and now we go to the sentence of the Declaration of Independence just after the one I've now quoted 3 times, it's the obligation of the government to protect and honor these basic fundamental rights that all human beings have. And government goes wrong when it dishonors them or fails to protect them. It's perfectly fine to say that's a religious statement. That's fine. And it's a religious statement about the foundation of our rights. Now, of course, it raises the obvious question that Americans have debated forever. What about unbelievers? Can unbelievers be good Americans? They obviously can't take literally the words of the Declaration of Independence. They can't take literally the words that all men are created equal, or that they're endowed by their Creator with certain unalienable rights. Well, this much I myself would say: whether or not any particular individual, including the unbeliever, can in good conscience say those words, endowed by our Creator, that person is a human being who, in view of the commitments we as a nation have made, beginning with the Declaration of Independence, is protected by the principles of American constitutionalism, beginning with the Declaration, going up through the Constitution and its amendments. And I think unbelievers can wrestle in their own minds and hearts with how they themselves would account for the existence of something like fundamental human rights that governments cannot legitimately take away.
Now, I have an unbeliever case I want to get to, but
Sure.
While there are a couple things we sketched out, I'm going to try to make sure we hit a few points before we take some of your questions. One, just to wrap up on the 10 Commandments, that the case, that the way that, for those who don't recall, the way the court decided in that case, it actually had to do with the longevity of the display. The display in Texas had been sitting there, this monolith had been sitting there for nearly 50 years and had not caused any known dissension or problems until the lawsuit was filed. The display in the Kentucky courthouse, the record showed, had clearly been part of an effort by the new leadership of that county to make a religious statement, and they had tried many different religious displays, narrowing them, trying to fall within the court as each one was challenged as being too much overtly religious and doctrinaire. And the court basically said the religion clause is supposed to promote comity among the people and to allow everyone to do their own thing without us all fighting. Therefore, the real issue is how provocative is this? The old monolith on the lawn at the Texas Capitol, not provocative, just leave it alone. The new display in Kentucky was intended to be provocative, and it is intending to make a we are all this religion kind of point, and therefore that one runs afoul. That's pretty much how they how they decided it. Just a little aside, an article I shared with Professor George, the origin of those Ten Commandment monoliths that you might see around the country in different places, placed by the Fraternal Order of Eagles. They were endowed by the publicity department at Paramount Pictures, which was promoting the Ten Commandments movie. And they and the Fraternal Order of Eagles came up with a plan to place those around the country, and the studio sent Charlton Heston and Ann Baxter, Yul Brynner around the country to unveil these things, coincidentally, with a major motion picture. So that's America. Anyway, moving on from that, and speaking of unbelievers, one of the clauses in the original Constitution that you wanted to discuss was the Religious Oaths Clause. And that, of course, also relates to a case from 1961 I want to ask you about. But tell us about the Religious Oaths Clause, which predates the First Amendment.
It might be the most important religion clause in the Constitution. It's the one that no one remembers. And of course, it's there even before the Constitution is amended. It's in the body of the unamended Constitution. And what it says is that there shall be no religious tests for public office. I think this enabled us to be a country, a religiously diverse country, to be a country. So you could be a magistrate, a federal magistrate, for example. You could be a member of Congress. You could be the President of the United States, whether you are Protestant, Catholic, Eastern Orthodox, Jewish, Muslim, unbeliever, Hindu, Buddhist. It doesn't matter. There can be no test applied for a federal office. Now, we know in practice, as a matter of cultural practice, for most of our history, until fairly recently, for the highest office in the land, the president, it was pretty hard to be elected unless you were Protestant. We were a largely, overwhelmingly majority Protestant nation. And so during the Al Smith election, I think it was 1928, the Al Smith election, when Smith was a Catholic who was the nominee of the Democratic Party, religion became an issue. Now, he had every right under the Constitution to run. There was nothing to bar him from taking the presidency because he was a Catholic. He could swear the oath of allegiance to the United States, his religion notwithstanding. And yet, as a practical matter, he lost that election in part, I think, because the country wasn't ready to elect a Catholic or a non-Protestant president in those days. The issue came up again, of course, in 1960 in the Kennedy election. In that time, Kennedy was elected.
Well, he ran against a Quaker.
It's true. He ran against a Quaker. Richard Nixon was a Quaker. That's absolutely right. So I think in knitting together a religiously diverse nation and making it work, that little clause tucked there in the Constitution, the no religious test clause, really affirming that we are all Americans, irrespective of our religious belief. Even if we don't have religion, even if we're unbelievers, even if we can't say the words of the second sentence of the Declaration of Independence in good conscience, still we are eligible to hold public office. We're all Americans.
Now that, of course, dates from 1789. In 1867, Maryland adopted a new constitution which mirrored that clause and said that no religious test shall be required of any person who holds office in our state of Maryland other than affirming a belief in God.
Yeah.
Other than that, no religious test is required. And the Supreme Court had occasion to consider that clause written in 1867 after a gentleman named Torcaso, who wanted to become a notary public. That turns out to be an official position, was turned down by the county clerk in Montgomery County, Maryland, because he would not affirm a belief in God. And that case went to the Supreme Court. The court struck down that provision of the Maryland Constitution. Were they right? Were they wrong? Why did they do that?
Well, that is interesting because the original clause in the Constitution applies only to the national government, not to the state government. So it really becomes a matter of state law then about the situation for state office holders. It's certainly, I think, a result that we can all applaud.
Especially if you need something notarized.
Yeah, that's right. Whether the argument by which the court reached that decision is the right one, I think, is the controversial and interesting question.
Do you think you have a moment to talk, or if not, we can go on to?
Well, I wanted to raise another question and check something out with the audience. I mean, one of the issues we've had in this area about believers and unbelievers is the inclusion of the words "under God" in the Pledge of Allegiance. For a number of years now, I'm trying to remember the man's name in California. Is it Neufeld?
It's Newdow.
Newdow, yeah, Mr. Newdow in California, who's, I believe, an unbeliever, has been challenging the words "under God" in the Pledge of Allegiance. Now, since the 1940s, no one can be compelled to say the Pledge of Allegiance. We can't force school children to say the Pledge of Allegiance, even whether "under God" is in it or not. And in the 40s, "under God" wasn't in it. These are the famous Jehovah's Witnesses cases, Gabitis against Minersville, Pennsylvania, and West Virginia against Barnett. But in the 1950s, at the height of the Cold War, in a way that I think highlighted the contrast between the United States as a nation built on the ethical monotheistic premise of all men are created equal, and godless Soviet communism, the words "under God" were added, not by our friends at the Eagles, but the campaign was led by the Catholic men's order called the Knights of Columbus. Well, is it legitimate to stick the words "under God," or should they be taken out as a violation of the Establishment Clause of the Constitution? Does it violate anybody's religious freedom? Does it violate Mr. Newdow's religious freedom, even if he's not forced to say it himself, to have Congress actually approve, and it's a congressionally approved pledge, to have Congress approve a Pledge of Allegiance with "under God" in it? So my question for the audience is, how many of you know where the words "under God" came from? We know they were inserted in the 1950s into the Pledge of Allegiance. The original Pledge of Allegiance didn't have it. One nation, indivisible, with liberty and justice for all, no under God. Who is pretty confident they know where the words came from? I see my father. But a really small number. And the answer is, if you will recall, everybody will now remember it, at Gettysburg, when Lincoln prayed for the country's future, that this nation, under God, will have a new birth of freedom, and that government of the people, by the people, and for the people will not perish from the earth. So the words are taken from the Lincoln Gettysburg Address and inserted into the pledge.
So we will take some questions from you, and then maybe we'll all insert one or two more before we wrap up. Okay, how about here?
I wanted to, Robert Bork III has visited me at Princeton, and I promised him the first question.
If you could hold one moment.
Oh, Leah's going to bring you the microphone.
Thank you, Professor. Recently, the Obama administration suggested Muslim truck drivers acquire permits protecting their religious right to not carry pork or alcoholic products. At the same time, the government is cracking down on instances of Christians exercising their beliefs, calling them intolerant. What do you think of this double standard, and should both be protected under the Constitution or neither?
Oh, okay, good. I don't know all the details of the cases. You know, they're kind of general cases that you have in mind there, and I don't know the particulars of the Muslim case. So I'll just work with what you've given me there. And I think they both should be protected. To protect one and not the other is a double standard. I think to fail to protect either would be a failure to accommodate religious practice, and that failure of accommodation would itself be a violation of our religious liberty principles. So I would like to see both protected. I think the rights of all people, Muslims, Christians, Jews, unbelievers, Buddhists, Hindus, have to be protected, and have to be protected according to an equal standard. So that position that I've adopted is sometimes called non-preferentialism, that the government should reach out and try to accommodate people so that they can freely exercise their religion to the extent possible, but it needs to do it in an even-handed way. Now, sometimes, of course, that creates the borderline gray area, cases. If we let the Native American Indian Church practice the use of peyote, the drug, hallucinogenic drug peyote, in their religious practices, does that mean that if another group says, well, we want to use heroin as part of ours, that they have to be accommodated? And here, some factors kick in that have to be taken into account. Public health, safety, and morals issues. Is heroin more addictive than peyote? Are the long-term consequences for the user greater with heroin than with peyote? Is there a greater danger of someone under the influence doing harm, like getting in a car and driving, or going on some sort of rampage with the one than with the other? You can't just resolve this by having a general principle that says any religion that, as part of its bona fide practice, uses otherwise illegal drugs has the right, because it's a matter of religious practice, to use them. You've got to look at the larger consequences. Under our Religious Freedom Restoration Acts, we have one at the federal level, and then we have the ones at the state level. There's a test that's used where the religious claimant believes that an otherwise neutral general law, like the drug laws, that were not created to harass people because of their religion, where you have an otherwise neutral general law but impinges negatively, it impinges negatively on the religious practice of a person, then the state or the federal government has to show that the law is necessary to advance a compelling state interest. It's quite a high standard. You have to show that the law is narrowly tailored. It's the least restrictive or least intrusive way of advancing an interest that is really a high governmental interest. So I would want to see that applied across the board equally to all faiths. Yeah,
Although, yeah, I will, but just again, that, however, is kind of tricky, because who is to say, when, for instance, federal government classifies marijuana as a Schedule I drug, like heroin, just as bad as the worst possible addictive antisocial drug you can have. Here in the District of Columbia and several states have completely decriminalized marijuana because they have a different view. So according to the official policy of the federal government, marijuana is just like heroin, probably maybe, I don't know the schedule of peyote, maybe worse. So who is going to make that decision if a practice that is otherwise prohibited or required by law, qualifies for this kind of exemption or not? Is it back to our unelected judges?
Well, I think it really is a jurisdictional question, and it will differ, I think, with the particular jurisdiction. So you're not going to have state uniformity here. Different states are going to resolve this in different ways, and I think different states can legitimately even handle it differently when it comes to the who decides question. To what extent should the authority to make the decision be in the legislature, and to what extent should it be in the courts? If Nebraska wants to weight it in favor of the legislature, and Oklahoma wants to weight it in favor of the courts, I don't think there's any good constitutional federal reason for the federal government to try to adjudicate between the two. That's what federalism is. That's how it should work.
Sir, hang on.
Yeah.
And Leo,
go ahead.
how about you can you select our questioners for us, because you can have the microphone around.
So we'll take this question and then
Well, just a clarification on Ten Commandments. I've always wanted to know. I believe they appear more than once in Genesis, and they're not quite the same. And I know if you learn them in a Baptist Sunday school, they're different from a Catholic school. So if you put up a Ten Commandments display or swear an oath on a Bible, there's different versions, and is not the selection of one version over the other is somehow favoring one sect or one translation or one tradition over another?
Yeah, you're right that there are differences, and there are differences of interpretation. I myself don't think that we should try to resolve anything based on those differences. We should just go along with whatever the proper authority that makes these decisions generally wants to do, whether they want to use the King James Bible or they want to use a different translation. There's not enough in the differences, I think, to make it an issue that we should worry about all that much at the political level.
You've got a Protestant and a Catholic. I mean, clearly, you put up Ten Commandments, it's going to be Protestant or Catholic.
Yeah, that's why. I mean, I wouldn't mind either way. It just would, to me, it wouldn't be a problem. If I had to resolve it according to a principle, the principle I would use is, why don't we just use whatever the founders themselves used, if that's available. So if the founders, if the common translation at the time, or the common version that was used at the time of the founding was this version rather than that version, when it's probably best to use this version. But one of the good things is we don't, Protestants and Catholics, at least today, don't really get into big fights about, which version of the Ten Commandments goes up. For people who think that it's a good idea to have the Ten Commandments up there at all, whether they're Protestant or Catholic, they're just happy that the Ten Commandments are up there.
Yeah, sometimes they just have Roman numerals on them. They don't even say what they are. Or,
yeah.
Of course, there's the Mel Brooks version, right? Like, I bring you 15 commandments. Whoops. 10 commandments. Okay.
Yes. You rightly said that the tenets of ethical monotheism underlie the Constitution, but we should also not forget the European Enlightenment of the 18th century. I'm especially thinking of Jefferson. All of these truths we hold to be self-evident. What he's appealing here to is natural law, the rights of man, natural, and the basis for this is not necessarily religion, because we have all sorts of different contending religions, but reason. And it goes back to the Stoics, who wanted to all citizens of the Roman Empire, regardless of their religions. There's one superior appeal, and that is to reason incarnate, self-evident truths. So again, this appeal, beyond God, beyond the king, when you're talking about, it's not necessarily to a creator, to a near deist like Jefferson, but to natural law.
It's a very good point. It is important to keep in mind the Enlightenment influences. And there were diverse Enlightenment influences on the American founding. And to make matters even more complicated, there are diverse Enlightenments. The philosopher Alasdair MacIntyre has wisely reminded us that the French Enlightenment, for example, was very different from the Scottish Enlightenment. So it's a complicated mix. Now, a couple of points about Jefferson and his influence and the concept of natural law. Certainly someone like Jefferson does not distinguish his natural law doctrine from his theism, or what you call deism. I think it's actually better to call it theism for a reason that I'll indicate in a moment. It's become a convention to call Jefferson a deist, and I think it's a good deal more complicated than that. But his idea is that there are laws of nature and nature's God, that God enlightens the mind so that the mind has access to moral truths. In this, although they're different in very, very many other ways, obviously, in this, Jefferson's view is not unlike the view of Thomas Aquinas, who believes that God has put in man a power of reason, a literally God-like power, a power not possessed by the brute animals, that enables man to sometimes be able to attain profound, important truths without deriving them directly from Scripture or from any other religious authority. So he does believe in the laws of nature and nature's God. Reason grasps them, but the ultimate source of them is God. Now, on the deism-theism question, which I find really fascinating with Jefferson, yeah, he makes noises sometimes that sound like what we would today call a deist, the guy who believes that God started the whole thing going. He kind of like threw the lightning bolt out there and started the whole thing going, and then stepped away, and everything goes on. The machine goes of itself. But remember this Jefferson, who, despite being a slaveholder, I notice that a lot of my students don't know much about Jefferson, but they know he was a slaveholder, right? Despite being a slaveholder, it was Jefferson who said, "I tremble for my country," speaking specifically of slavery. "I tremble for my country when I consider that God is just and that his justice will not sleep forever." That's not the deistic God who doesn't care what happens in the world of human affairs. This is the God who is active and willing to judge, willing to cast judgment on sins, including national sins, like slavery. So Jefferson's a very complicated guy.
Interestingly, the the Confederate States Constitution, which in many ways mirrors the U.S. Constitution, but tries to improve upon it, they added God to the preamble, which is missing from the U.S. Constitution. So they didn't help in the end. Okay, so do we have time for one more?
Yes, one more from the audience, and then we'll conclude.
Okay.
Yes, thank you for this marvelous, informative time. Currently, right now, we have the issue of the Supreme Court decision on gay marriage. And also, just a week or so ago, we had the lady from Kentucky, Kim Davis. Yeah. Mm-hmm. Do you anticipate, I'm asking, this is the question, do you anticipate that there will be a movement among those that want gay marriage forced down our throats, into our churches, into our publications, and all the different things in terms where the free exercise clause is not going to be able to protect those people of religious background?
Well, maybe I can also reframe it a little bit because it plays in directly to the news today. The Sixth Circuit declined Kim Davis's petition regarding her contempt citation from the district court. She's, of course, the clerk in Rowan County, Kentucky, who chooses not to issue any marriage licenses to avoid issuing them to gay couples. She's made a religious exercise claim there. I'm wondering what you make of that claim as a constitutional matter. I mean, she has some statutory claims as well under state law, which the Sixth Circuit told her to address to a state court. But in terms of our federal constitutional tradition, where do you think she stands in her claim as we try to reconcile these different strands in our constitutional tradition?
Okay, it's a big question. Let me begin with just a word about Reverend Shelton's half of it, and then I'll come back to Jess's half. Long before the decision was handed down, many years before the decision was handed down, one of the leading gay rights activists, who's now a member of the Equal Employment Opportunity Commission, Kai Feldblum, Kai pointed out that she foresaw a massive number of conflicts between what she would call sexual rights claims and free exercise or religious liberty claims. And then she said, I have a hard time thinking of any cases in which I think the religious liberty claim should win over the sexual liberty claim. So that's obviously reflects her own view about the importance of sexual liberty rights. I have the opposite view from hers, but I agree with her that there will be a massive number of these cases. And I think people who said that it was unlikely that there'd be many conflicts between sexual liberty claims and religious liberty claims were just wrong. And many cases had their heads in the sand. I think Kai Feldblum was right on the mark and saw it coming, and you see it playing out today, not just with Kim Davis, but with the bakers and the florists and the people who rent the halls and so forth and so on. And I think we're just going to see more and more and more of this. I want to see, so I'm at the opposite end from Kai, who's a professor at Georgetown University Law School and also, as I say, serving on EEOC. I would like to see the religious liberty claims win far more often. But to say why, we'd have to debate out the underlying political and constitutional theories that she and I would represent as proponents of. I am in the small minority of constitutional scholars who believe that the Smith decision, Employment Division of Oregon against Smith, was decided correctly. This is the decision in which Justice Scalia, joined by, literally by 5 members of the court, but for the part that's pertinent here, by 4 members, forming a 5-4 majority, because Justice O'Connor did not join him on the issue I'm going to talk about here, holding that the court had been mistaken in interpreting the free exercise clause of the First Amendment as creating a judicially enforceable religious liberty right requiring the states and the national governments to apply the compelling state interest least restrictive means standard to laws of general applicability, neutral laws of general applicability that happen to impinge negatively on the religious practices of citizens. So when that decision was handed down, which I thought was actually correct, because I think it comported with the original understanding of the Constitution, when that decision was handed down, it created a firestorm. You've never seen the right and the left so united. Everyone from the liberal People for the American Way and the ACLU to Jerry Falwell's Moral Majority and Pat Robertson's Christian Coalition were all united. Barry Lynn, if I recall correctly, and Richard John Newhouse, all united from the left to the right in saying the decision is an outrage. The decision reads the Religious Freedom Clause, Free Exercise Clause out of the First Amendment. It's a disaster. But I thought it was correct. Now, in response to the decision, the federal government and many states did what I also think was correct, which was to enact a federal and state statutory protections for religious liberty that would restore as a statutory matter, but in control of the legislatures, the compelling interest, least restrictive means test. That Religious Freedom Restoration Act at the federal level was struck down as applied to the states, but not as applied to Congress or the national government. In response to that, a number of states did what I think is exactly the right thing. They enacted state RFRAs. And of course, the Supreme Court rightly says they are perfectly constitutional. So what I would like to see is those state religious freedom restoration acts applied. I'd like to see them applied to Muslims, Robert, who, for example, would not want to be involved with the alcohol business, or to Jews with respect to things like infant circumcision and the slaughtering of meat by kosher law.
Blue laws? What about blue laws?
Well, blue laws is an interesting case. We can talk about that
next year.
And of course to Christians, including people like Kim Davis. So I think that the way it should be handled in Kentucky, and North Carolina is already doing this. Ryan Anderson has pointed this out, is to handle it by the application of a Religious Freedom Restoration Act standards, so that if someone has a legal right to a certain license. Now we're going to, for Reverend Sheldon reasons, we have to just stipulate for purposes of argument that the same-sex partners who are seeking the licenses do have a legal right. That raises the question of the legitimacy or the status of the Obergefell opinion. And this is another big issue that we could invoke Jefferson and Lincoln for on the question of judicial supremacy and whether the Supreme Court actually has the constitutional authority to do something like what it purported to do. We have this issue going all the way back in our history to the Dred Scott decision. But just stipulate for the moment that there's a legal right to a certain license. Then the question becomes, can the religious freedom claim of, say, a Muslim clerk now, who is being asked, among many, many other duties, to issue a liquor license, or a Kim Davis being asked to issue a marriage license in where the partners are same-sex partners, the rule would be that she should be accommodated, that clerk should be accommodated if the people who have the legal right to the license can, without excessive difficulty, get the license by having, for example, somebody else in the office if there's somebody available.
Well, she said no, and she said they can go to the next county. Is that enough of an accommodation?
Well, I mean, did she?
That's what she's. I mean, you know, the next county is.
So she said no, that no one in her own office
right.
could. Okay. So I think the way to handle that.
And no
again,
marriage licenses. Period. I'm not. It's,
right.
I'm not giving them to anybody.
Yeah. On again the stip.
We don't believe in marriage in Rowan County. Go.
Yeah. Right. Yeah.
Go over to Harlan County. Go somewhere else.
Then if it's Harlan County, we get into the liquor issue again. I know Harlan County. I grew up in West Virginia. I know it's right across the border. I know Harlan County. So. If she's saying that nobody in the office should be able to,
her name's on the form. If my name's on the
right,
form,
and, well, no, so right. See, that's the problem. I think she's right if she says if my name's on the form. Then the correction that needs to be made is to make sure that her name doesn't have to be on the form.
So the judge, the district judge. Let me just make sure that we know the right answer.
It should be Kentucky. It should be the Kentucky State Legislature.
But right now, where we stand right now, the Department of Libraries actually is in charge of this. You know, you guys have a lot of power. The Department of Libraries writes the forms apparently for state, documents of this kind. And the form for a marriage license in Kentucky, because they're issued through the elected county clerk, has the name of that county clerk printed on it, even though she does not personally have to physically, print it and, give it to them. Her name is on the form. Even if she doesn't sign it, her deputy signs it, her name is somewhere on that form. That's what she doesn't want. And she says, as long as my name is on that form. Now, Kentucky legislature may well pass some accommodation that just takes the name of the individual name of the clerk off the form, whatever they do. But right now, today, her name is on the form. She is told, or did before she went to jail, her clerks not to issue these licenses. The district judge held her in contempt because she forbid her staff from issuing them as well. And the deputies began issuing these licenses. She came out and said, okay, I'm not going to get in their way, but I don't think these are valid licenses.
Well, I think she's got a valid RFRA claim, if I understand the Kentucky RFRA, if it's like the other state RFRAs and like the federal RFRA. I think she's got a valid claim about her name being on the form. That should be accommodated so that her name is not on the form. The question then becomes how to get her name off the form. And if you can't get her name off the form, in other words, if Kentucky as a state won't recognize a marriage unless, in that county, unless it's got her name on the form? Is that where we are?
The question is really, that RFRA claim, the Sixth Circuit said, we're not going to adjudicate your Kentucky RFRA law, take it to Kentucky State Court. I'm sure she will. Until that is resolved, and she may well win, it's not much of an accommodation to just cross her name off the form. Until that happens, who prevails? Her right to not have her name associated with these marriages, or the right of the both of the couples of same sex and different sex who are seeking the until we resolve it in a way, who's going to win? Who should win?
Well, I mean, I think then it becomes how difficult is it for people in the county to go out of the county to get a license? If it's within an hour, let's say, just as a rough, because we're trying to think of what constitutes a least restrictive or least intrusive means here. We're evaluating things at that level.
Judge said, if I grant you that, then what's going to stop all these other clerks from doing the same thing? And they're going to have to go.
Well, they could, and then of course the actual outcome might shift. If it becomes a 5-hour ordeal for anybody to get a marriage license, then under the RFRA standard, you get a different result than if it's driving for half an hour. I mean, that's how RFRA actually works. I mean, when it was
being a tough reporter trying to nail you down before everyone has to go, I would say, so, Judge Bunning, right or wrong?
I think Judge Bunning is wrong.
He's wrong.
But
he ordered
I think we're now in the Sixth Circuit and going back to.
Okay, so when he said,
oh no, Judge Bunning
licenses,
should not have sent her to jail. That was a mistake.
Or you're in contempt. You should not send her.
This thing, there's an accommodation issue here. There's a way to solve this. North Carolina's already pointed the way, and all this is on the stipulation, right? We got a separate issue about the status of the Obergefell decision, but on the stipulation that we're going to treat that as law of the land, then I think it's a straightforward RFRA accommodation analysis. And I think basically it's get her name off.
So he should have ordered them to just take her name off the form.
If he could do that consistently with Kentucky law. So we need to know the details about that, because we don't want the
He's
judge.
a federal judge.
That's right. We don't want the judge overreaching here. But the right result is to get her name off. She doesn't want to sign her name to a marriage that she thinks is not actually a marriage. That's a legitimate religious freedom claim.
And if he doesn't have the power to take her name off, who wins? Because he didn't seem to think he had the power to fool around with the forms. He just said they get a license.
Then we're back to the question of how difficult it is to get a marriage license somewhere else. As long as, and I think this is another significant portion of it, as long as she does what I gather she did do, which is to say, we're just not issuing marriage license. So she's not picking and choosing who to issue marriage licenses to. She's just saying, if you want a marriage license, you have to drive to the next county. If it's a 5-hour ordeal under the RFRA standard, because it is shifting, the standard does shift. It's about how difficult it is to accommodate the religious liberty claim. If it's a 5-hour ordeal, the case comes out one way. If it's driving a half hour, the case comes out another way.
Does it depend on whether you have a car?
Whether you have access.
So there you have it. The Constitution, it's a pretty tough document to figure out.
Although what we're just talking about at the end is not actually a constitutional question. What we're talking about at the end is a state statutory question.
She's made both constitutional claims and statutory
She'll
claims.
lose on the constitutional claim. Where she's got a stronger case is at the state statutory level.
And we'll find out how that turns out. There are for your Googling pleasure, because we had so many things to talk about we didn't get to, I'm very sorry we didn't get to talk about the Blaine amendments.
Oh, right.
Which involve tax support of, what, we have 3 minutes?
On the website it said till 3.
Oh,
1 to 3.
well,
Yes. We printed it off.
People want their money's worth.
I see. Well,
I think I have a 3:05 train.
okay. Well, I will, I bet you don't get that at Princeton, huh? Your students saying, can you keep going?
Can we keep class going?
I can stay longer, but I will leave it to you guys because I don't know anything, so I won't help you. The question is, can he?
I have to catch my train.
He has to catch his train. Okay, so the Blaine amendments, which involved state support of parochial or religiously affiliated schools, that was one topic we didn't get to. We also didn't get to talk about something that is quite important going forward, which is Professor George's work on the International Religious Freedom Commission, where he is the chairman. And that is it's a body which aims to promote our American view of religious tolerance and pluralism in other countries, and that's a very important topic by itself. But we won't talk about it today. So what else should they look up to learn about that we didn't get to talk about?
Well, again, if people are really interested in the question, go back to the No Religious Tests Clause. It's the forgotten clause of the Constitution. Certainly in the religion area, that's something to be looking at. Also, you have this very interesting set of questions that came up in the Hobby Lobby decision about the Federal Religious Freedom Restoration Act. There's a great deal here that we didn't cover, I'm afraid. But thanks to everyone for sticking with us for what we did cover.
Thanks.
This has been a presentation of the Library of Congress. Visit us at loc.gov.